We're still in. I'm moving to DC sometime in the next year.
All right, guys, I think we're getting going here.
Family decision.
My name's Carl Marsh. Welcome to the second panel today, which is, I think, appropriately titled, What Keeps In-House IP Counsel Up at Night? As you can see, there's four of us here, and then we have Mehul Shah up above us. Mehul is based in Pepper Pike, Ohio, but he is in LA today, so he's joining us remotely. Mehul, can we hear you?
Hi, good morning. Does this work?
Dude, perfect. I love technology. So before we get going, I want to say a few things. First of all, super excited to be here. This is the second year we've done this conference. This is the first time it's been in person. And very excited about what Cleveland Marshall is doing with the IP program. Obviously, they brought somebody in like Krista, who has huge credentials coming from 2 international law firms and having, a very sophisticated view of intellectual property. And really, I didn't go to Cleveland Marshall, but the fact that Cleveland Marshall is building an IP program is a recognition of the fact that there's tons of IP lawyers in Cleveland and in the region and nationwide that went here. So it all makes perfect sense that the IP program is growing. And I'm really excited about the kind of things that we're talking about. Jen Boyce sat on the first panel and said she's kind of apologized for not being an IP lawyer. It's like, no, you're here because you're not an IP lawyer. Like the IP conferences, my clients always tell me, I'd love to go learn more about IP, but when I go to your conferences, y'all speak in code and I can't understand your inside jokes and it's a bunch of jargon. And so our goal here in being the IP Plus conference is to kick it up a couple levels and talk at a higher level about the strategic use of intellectual property. And I think you're going to see that throughout the day. And especially our keynote speaker, Laura Quatella, who's General Counsel of Lenovo. And the reason she's here is when she was at Kodak, she made $4 billion monetizing intellectual property. So she has a significant experience doing that. And then we've got afternoon panels that are, super interesting, including this panel, which is a morning panel, but is also super interesting. And by the way, I'd plug Ari Sherwin, who did go to this law school's panel. When's the last time you went to an IP panel and you heard from an Olympic gold medalist and a former player in the NFL? It's crazy what we're putting together here. So we hope you enjoy today. So introduce all of our panelists today. Greg Kolocouris is in-house at Eaton. Chris Storm is in-house at Uber. Jason Strobel is in-house at Materion Corporation. And then Mehul Shah is in-house at Juniper Networks. So what we're going to do is I've asked everyone to give you a brief biographical sketch of not only their role now, but how they got there, because I think it puts in context the issues that we're going to talk about with respect to intellectual property law from the in-house perspective. Craig, you want to start?
Sure. Thanks, Carl. I've been with Eaton 14 years now. Currently, my role is business counsel and intellectual property counsel for our vehicle business, as well as our e-mobility business, which is primarily electrical vehicle focused business. I've been practicing for 20 plus years. I started off mechanical engineer undergrad, actually did some manufacturing engineering for a few years, then started my legal career, was with a law firm here in town for about 8 years, primarily doing patent prosecution and in the early days, and then started doing more opinion work and a little bit of litigation as well, patent litigation. I was actually doing some Eaton legal work at the time, was actually working on a patent litigation for Eaton while I was with the law firm. Got hired into Eaton, primarily supported a number of our electrical businesses for roughly 10, 11 years. And then the last couple of years, I've been doing this dual role of business counsel and IP counsel, which is pretty challenging, but I've learned a ton in the process, and so that's where I stand today.
Chris, by the way, my mistake. I didn't realize this when this panel got constructed, but we have a panel in Cleveland, Ohio, that actually has 2 Steeler fans on it. So I apologize.
I'm a Cowboys fan.
Oh, that makes it better.
I was born in Texas, and when you're 8 years old, you make a decision to make it for life. I don't like being a Cowboys fan, but I am.
I'm the Steelers.
That's my that's my introduction right there. My name's Chris Storm. I'll save you some time. You don't have to look me up. I'm not a former Olympic athlete or NFL player. A quick biography. I started my career at a firm. I went in-house to Bell Helicopter. They were one of my clients, and I was, frankly, as a young associate who questioned everything, I was really fascinated by companies who filed patents on inventions that I was like, why is this worth the money? So I wanted to get closer to that decision-making process. When I got there, I wanted to continue understanding that decision. I ended up going back to business school and getting a master's in technology commercialization, where it's like an entrepreneurship program. So I was like doing pitch competitions in front of people like Todd on the first panel, which is terrifying. And then I got the opportunity to join Uber in 2016 to be their head of IP for the self-driving program. So I moved from Texas to Pittsburgh at that time. That grew into being head of legal for all of emerging technologies. So self-driving, Uber Elevate, AI labs. They put jump bikes under me for a little bit. So I was feeling nostalgic walking around looking at all the former jump bikes that are now line bikes. And then in 2020, I helped Uber sell all my clients. The pandemic hit, nobody was taking Uber trips anymore. So we sold Jump, we sold Uber ATG, the self-driving program, we sold Uber Elevate. And Uber was nice enough to let me stay on and gave me the freedom to kind of create my own job. So I still work on the self-driving side, bringing companies onto our platform. I do a lot more patent policy work, IP policy more generally, and then jumping on litigations, M&A deals, whatever they need. So a little bit of everything now.
Can you, do you have control of the algorithm that would let me change my rating to 5.0?
I do not even know my own rating. I'm so far removed from that.
Jason?
So good morning, and maybe even before I introduce myself, thanks for the invitation, Krista. This is really good, and it's exciting to see that we've got this sort of enthusiasm. Carl, thanks for agreeing to moderate this. I think also would be really a fascinating discussion based on some of the talks that we've had leading up to this. So my name is Jason Strobel. Today I'm the Senior IP Counsel at Materion, and you might say, well, who's that? If you've seen the James Webb Space Telescope, and I think most everybody has, if you see the gold mirrors on there, that hexagonal panel display, that's us. And so we're out there. We're helping to see everything that's happening now as far as we can see, as far back in time. And I came there 4 years ago because they asked for someone to come and set up the IP program. And so that's what I've done now for the past 4 years. Before that, I worked at Avery Dennison for 5 years. That was my first in-house role. Prior to that, I worked 7 years at a law firm. And before that, I was a material scientist. So I did that for 5 years. And I thought, wow, I don't have all these great ideas. Wouldn't it be good to work with some people who do? And maybe I could help them to protect those. That's how I ended up actually as a lawyer. And I've just worked my way through, slowly trying to understand more of not necessarily how do you be the best IP lawyer, but how do you become the best business counselor who also happens to be a lawyer. And I think ultimately what we'll see today is all of us have built our success based on that more than anything else.
That's absolutely true. And that's absolutely why you're on this panel. So thanks for being here. Mehul, take it away.
Yes. Hi, good morning. And really thank you for the opportunity to be on this distinguished panel. I've learned a lot talking to everyone and looking forward to the discussion. Yeah, my name is Mehul Shah. I'm the head of patent standards legal at Juniper Networks. If you're not familiar with Juniper Networks, we're leading the industry in networking, software, and hardware. We form the backbone of telecommunications and the internet. I've been in the software industry for about 20 years. I started my background in computer science. I was a software engineer at IBM. Then after many years, I thought, I'd like to stay in technology, but I'd like to focus more on innovation and business. So I went to law school, with the plan to become a patent attorney. Through law school, I had various different experiences in-house that made me realize that's sort of where I want to be. I started out in private practice, building a strong foundation in patent prosecution, supporting litigation. After that, I went in-house, and I soon learned it really is a business role. It requires you to think about things in different ways. I went to a European Swiss company where I was at for a few years, leading the patent team there, doing strategic patent portfolio development, and we were also very active in licensing patents and building value for the company. They had a strong portfolio. I'm currently at Juniper. I've been here for a couple of years. I lead a team of attorneys. We handle all patent matters at Juniper. We come up with strategies to build our portfolio, create value, freedom to operate for Juniper. Part of what our team also does is handle standards, legal issues. Juniper is very active in the standard space for telecommunications and networking. So we handle all the participation, legal. We're also very actively involved with industry in helping shape policy and the legal framework. So really happy to be here and share more about our experiences.
And my name's Carl Mersch. I started my career here in Cleveland at Jones Day as a patent litigator. I went in-house to Kodak, where I did a bunch of things, including monetizing intellectual property. I was then head of IP litigation worldwide for Dow Chemical for a number of years. And for the past 8 years, I've had a small consulting firm here in Cleveland, and I advise companies on intellectual property strategy issues, including monetization. About 3 months ago, I folded my company into Hilco Streambank, and I now run my company as a division of Hilco Streambank. So that's why you see me as senior VP, and thank you to Hilco for sponsoring this panel, by the way. But that's our background. So what we'll do now is sort of round robin a bunch of topics on what keeps us up at night. Might be a little bit of a, or what keeps you guys up at night might be a little bit of an overstatement, but certainly these are the issues that these guys see and that I used to see and that I advise clients on. So Mehul, why don't we call on you first? So one thing that you surfaced is ensuring that the company is capturing all the innovation that it can. Tell us about that and how you deal with that.
Yeah, absolutely. So, being leader in the industry, comes with its challenges, right? And one of those challenges is staying ahead of the competition in the industry with regard to patents. An important part of our business is making sure we have the freedom to operate, protecting ourselves from competitors, protecting ourselves from companies that are looking to build value and monetize their patents. Because we're part of various different standards organizations, that also becomes very important to us. Making sure we're collaborating with the right companies and we're setting standards that help the industry and also ensure Juniper to grow its business. And so with that, we're not just looking to protect what we're doing now. We have to really think ahead of where our business is going and where the industry is going. This is very difficult. The industry is moving very fast. Our company is going in a lot of different directions. From the legal perspective, from patents and standards, it's become a global playing field, especially in particular jurisdictions like China, Europe, and then US, of course, where there's a lot of litigation and activity, designed for companies to advance their business and stop others. And so beyond just managing the day-to-day, patents, it's really about keeping up with their business. Development is moving very, very fast these days, to keep up with the industry. So, what do we have to do? We have to work very closely. It really is a business role. We work very closely with our product management in the company, our engineering, the business folks to understand where the business is. And we use all those different dimensions to really figure out what to protect and how to protect it, not just getting the innovation from the people that are, working on things now.
Anyone have any input on that?
I can add, we have some of the same challenges as well, although, we're more mechanical, electromechanical, but we're becoming a lot more digital. And that presents, additional challenges, a lot more software and whether or not to patent or trade secret and things like that. So it's a challenge to get everyone on the same page and to make sure that we're appropriately protecting the innovation that's being generated and looking ahead. And, we have product roadmaps and we're trying to, make sure that our strategies are aligned with those roadmaps. And Eaton makes thousands of different products. So it's not, every product line can have its own strategy, and trying to align with that can be challenging. But it's something that, we have to work hard at and make sure that we're working with the right people as well. Because sometimes, we call centers of excellence or research labs that are part of like corporate research, and making sure there's alignment there can be challenging as well. But it's something that just requires a lot of communication and a lot of collaboration to make sure things are being appropriately protected.
Chris, Jason?
Yeah, so I mean, the question you asked is kind of interesting, the wording, as an in-house IP counsel, capturing all the innovation, right? And in some respects, that's kind of not it's often described as our job, but in some ways it's not our job, right? The way I like to think about it is actually capturing the minimum amount of innovation to achieve your business objectives. So in-house patent strategy, but no matter what your company is doing, your patent strategy tends to fall in one of two buckets: commercialization or monetization. Commercialization, I think of it as using your patents to help your company profitably launch a new technology product. Monetization is using your patents to collect money from other people who commercialize, right? And so both of those are budget constrained. On the monetization side, every dollar you spend on investing in patents and getting patent protection needs to have a rate of return of $1 or greater, right? Otherwise, you're not making a great investment. On the commercialization side, every dollar you spend needs to either save you $1 somewhere else in the company or help you increase the value you get from selling products by $1. There's a point, though, where you can overinvest. And especially if you're on the commercialization strategy side, if you are over-investing and you're actually getting more patent protection than you need to achieve those business objectives, then you're taking money away from the other parts of the company, the testing, the marketing, the sales, and so forth, that's actually going for the same commercialization strategy. So if your strategy is commercialization and you over-invest on the patent side, your strategy is at best inefficient because it's taking away from the ultimate end goal.
And don't you find that analysis, which you set up as occurring when you're deciding whether to file or not to file, that same analysis can be applied throughout the whole life cycle of the intellectual property you have? Because markets change and situations change, and you can get into a situation, and I had one in my career at Dow where Dow invested in heavily in this plastics business because it had a significant amount of revenue. And then when I came in, they're like, yeah, we have all these patents because we have all this revenue. And I'm like, yeah, but our market share is like 60%. And there's like 2 other players. Who would we sue? Why are we keeping these patents, right? And so like what you said is true at the front, and it's something that should be applied throughout the entire life cycle because the facts change.
It's even more true on the back end. So when you file a patent application, you know practically nothing. You have very little feedback in terms of how likely is that invention to be commercialized by somebody in the future, whether it's you or somebody else. Over time, you get that feedback, you learn those things. You see that, what there wasn't a market before, a market develops, or maybe it doesn't. Maybe something fails in testing or whatever. And so you're making at best an educated guess when you file, and you're sitting through the process, and you're gonna eventually, maybe you'll receive a patent, you'll file in other countries, you're gonna start paying annuities and maintenance fees. all of those financial decisions are an opportunity to revisit that investment decision based on what you learned.
Yeah. I'm going to go in a different direction unless you have something you want to say on that. Okay. Jason, I'm going to you. So we've talked just, we've started with patents, which, it's an IP conference. I think we're obligated. But your company makes significant use of trade secrets, which is a whole different set of issues. Can you talk about, those issues and how you manage that?
Yeah, so I think even backing into the question a little bit, what we talked about is, well, what are the things that keep us up? And the keep me up night at questions don't often have anything to do with our patent strategy, right? And that's, people know what to do in general, and we know how to monitor it, and we know how to work and manage the portfolio. But the places where we see opportunity, real challenges, are people walking away with information. And so, because so much of what we do as a manufacturing company is based on our processes, many of which we choose not to file on because we have an awfully difficult time policing that, we necessarily have to build out a large bank of trade secrets. And as we do that, one of the things that we're always cautious of is, one, well, who will walk away with information? In fact, yesterday we had one of our inventors resign. And so immediately we have to think, what information does this person have access to? How do we make sure that none of that leaves the building? Have we made an efficient use of agreements even when we hired the person so that they know of their obligations when they're leaving? So it really is, it's not just in the moment, but it's how do you build that trade secret program so that you're effectively and efficiently gathering information in the beginning if you choose not to file on things. How do you monitor that? How do you continue to protect it all the way through? And then when you come to end of life of people or end of life of projects or products, how do you make sure that you keep that information as discreetly protected as you can? And that's not just a legal function, right? But that's a question of, what does the R&D community do? What does your information technology team do? What does your overall security team do? Because it really has to be a holistic approach, because no one owns all of them.
Anyone else on trade secrets? Mahul, anything on trade secrets?
No, nothing for me.
So the question, so trade secrets are fascinating, and I actually tried a trade secret case. Well, I was an in-house counsel when we did one trade secret litigation, and then we ended up doing a second one, and it started out as a patent case, and we discovered through discovery that it actually was a misappropriation case, which all of a sudden it got really interesting. And I learned a ton. And my question is, when you talk about keeping this as a trade secret, do you consider whether you're going to patent something and then decide to keep it as a trade secret? And there might be reasons for that. One, you don't want to disclose the secret sauce, or I think you mentioned policing, which obviously is an issue. Is it a secret sauce issue? Is it a term issue? Or is it a policing issue? And do you make that determination every time you come up with new technology?
So it's all of those things. And in some instances, it may be one more than another. But I think certainly when we get an invention disclosure, one of the first decisions that we have to make, and this is a bit what Chris talked about, is what's the investment that we're willing to make? And then the question becomes, what's the likelihood that if we make that investment, we'll get the return of investment? And even if we do, are we actually going to be able to exclude or monetize if we need to? Is this helping us to commercialize something? And so I think each of those, right, this is the three-legged stool thing. You got to think, can you enforce it, right? Can you protect it first? Because if it isn't patentable in the first place, well, why even consider it? And then once you've done all of that, what's the overall business strategy? So does it matter how long you protect it? Is it in a newly emerging technology where you think you might have some, let's call it foundational technology that is really good to get a stranglehold on? Or are you really toward the end of life where now what you're doing is more optimization than it really is innovation?
Yeah. So just like Russ Gannett checked the box of being in a law school and mentioning something that we all learned in law school, we've checked our box because the three-legged stool, of course, is something that came up in all our law school classes. So, Chris, when we talked, one of the issues that you said that came to you in your practice was what you call crisis management. Can you talk about that?
Yeah, I mean, I work for Uber, so everything's a crisis, right? Um, so, yeah, it was in the context, what keeps you up at night, and um, one like basically there will be times. I'm speaking to the law students in the room now. There will be times in your career where your work will keep you up at night. Hopefully, it's in a healthy way. Like for me, it was always about like, am I doing good work personally? Like, it's like when you put yourself in an area that you haven't worked in before, and you're kind of going through that imposter syndrome and everything else, and then you push through it and you get that skill, and then you sleep well. Especially moving in-house, communication skills are so different than at a law firm. It's very scary to like have to talk to people who actually don't care what the law is. Whereas in law school and in law firms, that's all you talk to is people, lawyers, and people who care about the law. So once you get through that kind of stuff, substantively, I feel like IP matters shouldn't keep you up at night. And I didn't always feel that way. In 2017, we got sued by Waymo for patent infringement, trade secret misappropriation. That kept me up at night. Like this was, not only was it a huge like case and media attention and really being hamstrung in how we could defend ourselves because of the media attention and other legal disputes that were going on behind the scenes, and the possibility that this could shut down the self-driving program, which is what it was designed to do. And that was very stressful. It did keep me up at night. And then a year later, we settled that case. And a month after that, I think I mentioned like I was head of all legal for the self-driving program. One of our vehicles struck and killed a woman named Elaine Hertzberg in Tempe, Arizona. And all of a sudden you realize just how silly some of the IP stuff is. Because, a lot of these disputes are rich people taking money from other rich people and nobody actually gets hurt. And so when you have to take off your IP hat and put on a different hat, and you're dealing with real world issues, not patent world issues, from that point forward, I've never stressed out about an IP matter because ultimately they get resolved and life goes on.
Yeah, it does. I mean, it's funny, right? What is a crisis? Because, for every company, IP, any legal issue obviously is a crisis, but, getting sued for patent infringement or something happens in a case and the issue with the company, especially if you're publicly traded, is what do we do? Are we doing a press release? Are we going to try this through the court of public opinion type of thing? And like, and of course, one of the things that used to come to me is, they sued us. We have to put out a press release that we don't do this, we don't do this, we don't do this, right? Going back to your example about people that don't care about the law. And you have to be managing your business people and saying, okay, we're not going to do that, mostly because that's not who we are as a corporation, but also judges see press releases and this is going to be exhibit A, and like we just have to deal with the legal issues and let the process play out. And for me, that was one of the biggest learnings going in-house is, it doesn't come up in a law firm setting, but it immediately comes up when you're in a corporation. I don't know if anyone else have any experience to talk about on crisis management?
Yeah, for me with Eaton, I mean, in the IP context, not much, but
Yeah, you guys are quiet. You guys are like a quiet giant over there.
Yeah, and not much on the IP, but certainly in business counsel, a number of issues can quickly get to the CEO, and then whether it's an external crisis or an internal crisis, you're trying to manage those issues and manage leadership in terms of how they want to react and what they want to say, and whether it's dealing with customers or suppliers or whatever it may be. So that's certainly a challenge, but knock on wood, we don't see too many on the IP side.
So let me segue with that to you, Greg. So one of the things that Eaton has is a significant patent portfolio. And you're not historically a company that sues people or makes a lot of noise or clangs your pots and pans over there. So is it an issue that I know it's an issue, I shouldn't phrase it that way, but I know you get called on to to articulate to the business why a robust patent portfolio is a good investment. Like, can you talk about that and how you do that and how often that comes up?
Yeah, it comes up periodically, mainly with new leadership. Not all the time, but that, sometimes certain individuals who come from different companies have different perspectives, and typically it's a good question internally, because we don't generally sue folks for infringement. We don't have a very large licensing program, and so the company overall has decided still invest in IP and in protecting our innovation with patents, and we do have a large portfolio, and so the portfolio does have value in and of itself, right, to the company. Now, when you get down to the business who's actually funding the IP and the patent portfolio, it's really about and Chris was talking about the commercialization versus the licensing, and like I said, we don't do a lot of licensing, so our portfolio is based a lot more on commercialization. We tend to know early on whether or not many of our inventions are going to find their way into a product, so that's a good thing. But at the end of the day, it's really about when we have these discussions with leadership, it's really the value that it's adding to the product or the product line. Maybe higher margins, maybe we're higher. We have, with respect to our competitors, market share, things like that. So we can show that, but we don't have a lot of great data to support it. Like I said, we have thousands and thousands of products, and so in any given product, you can't point to it and say, well, we have 50% market share on that because of this patent, because of that patent. But we generally are able to extract good returns on our products from a margin standpoint, and generally have high market share in most of our businesses. And so it's sort of like the scarecrow effect, where we're able to demonstrate that hey, we're keeping people out of the space, but it's not with numbers that we can quantify and point to and say, yeah, it's because of those patents right there. But we feel like that those patents are adding value, and I think overall the company realizes it, or they wouldn't be investing the money that we are. But sometimes we have to go through that education process.
It's funny too that you mentioned that it's usually new, or you didn't say usually, but you said it's new leadership, and that reminded me of something like when I was running litigation at Dow. There are business units that were kind of like stepping stones, where they bring leaders through for some period of time, and the first thing they want to do is obviously make this business profitable. And so they look at your, for me, it was litigation spend. It wasn't, you guys have, filing fees and prosecution costs and maintenance fees. But for me, it was burn rate on litigation. And the first thing they want to do is, we're just dropping this. And then you have to go, to use your example, you got to go up a level to the general counsel and sometimes to the CEO to be like, I get it, you're here for 18 months or 12 months or whatever, and you're going to make this business unit, your stepping stone, but we got bigger fish to fry here than just, this P&L this quarter. And I think that's interesting from an IP perspective, because it's like business unit doesn't necessarily understand the current value of IP, because for them, they don't have that horizon.
Yeah. Well, and just let me say, I by analogy, I often run into this and I say, well, if you want to save money, why don't we stop paying our insurance premiums? Because, well, that's a thing that we never use, right? And people will say, oh, we can't do that. And I said, well, okay, but I mean, isn't an intellectual property portfolio insurance for our ideas? And by the way, if you want, we can change the coverage that we have. And if we want a higher deductible policy, we can do that. Let's flex the way that we have the portfolio. But it's a particularly ignorant position to take, to say that we don't need a portfolio. And by the way, let me use this as an opportunity to educate you on why it's important. Because anytime somebody asks that question, I feel like it's our obligation to explain to them and teach them, because so much of what we do, people just choose not to understand because they say that it's hard, right? This is part of what we're trying to talk about today. Intellectual property isn't that hard if you put the time into understanding. And there are always willing people who will teach you if you're willing to ask. So come and ask us. Let us tell you. You don't go down to the tax and treasury department or the insurance team and say, hey, by the way, let's drop those insurance policies. Just like you shouldn't come and ask us to cut our portfolios without even knowing what you're asking.
Yeah. Chris, can you talk a little bit? When we talked on the pre-call, you had talked about, I think it was in the context of budgeting, but it sort of goes along with what Jason was just talking about. I think you had posited this as they're going to give you such and such a budget, and you have discussions with them about what you could reasonably expect as a return from intellectual property in that context. Can you talk about that?
Yeah, so we're actually in the middle of budget conversations right now. So this is one of my favorite subjects to talk about. So every year, we talk about the number, right? And whatever the number is they're going to give us, we're going to give them the maximum amount of IP protection and service for that number. And so if we want to move that number up, we're going to talk about these are the things we're going to add. And we can have a conversation about those specific things. But if they don't want to spend it, that's fine. If they move the number down, we're going to make decisions on what we're going to cut. And so it allows us to not have a conversation about like, we want you to cut filings, we want you to cut disputes or whatever it is they want us to cut. They're just going to tell us like, we need you to cut $1 million from your budget, and then we'll figure out the best way to do that. Having that kind of conversation helps in a couple of ways. One is there is the education element, right? All of us in this room live in this IP world, whereas the finance people, they're meeting with us one day, the next day they're meeting with the real estate team, the next day they're meeting with somebody else, and they don't know how what it takes to defend yourself against a non-practicing entity, like the things we spend money on and so forth. So education is important, but it's also time limited. Like we don't have unlimited hours to talk to the finance team because they got to talk to all these other people because they have their own budgeting deadlines. And so being able to distill it down to, all right, this is the number you're wanting to give us. We'd like to get to this number because we want to add these three things. Let's have a conversation about these three things, and we can demonstrate to you why this is a good investment. Makes for a much more concise budgeting conversation.
All right, Mehul, I want to ask you about switching gears a little bit, but sort of focusing on the legal department itself. I want to talk to you about team development, which is an issue that I know comes up in your practice. Can you talk about that?
Yeah, absolutely. So I think one of the things with an in-house legal team is, I think others on the panel too probably experience this, is you're being asked to do a lot at any given time. And so you have to balance the interest of the legal department, being able to handle the work and service your clients and the company with, balancing the interests of professional development of your team. That's sort of one challenge that we face in development. In the software industry, there's just a lot of movement in jobs. People are looking to build their skills. Legal departments are very lean, so people are basically looking to grow. So with that, I think the other challenge too is helping individuals grow within the team, building their skills while also trying to address the different needs of your business. I think a lot of what we discussed today as well is about communicating with the business. So I think there are a lot of other skills too that within the team that we look to develop those business skills as we work and communicate with the business. Sort of touching on the topic of budget, right? We're faced with these discussions all the time, limited with the budget. So a part of what we have to evolve to in our team is learning to rely on data. So we build a lot of process and tools in our legal function as well. So for team development, that's an area that we're looking to grow. We're also seeing a lot of mature patent programs and teams and companies looking to leverage tools and data science to understand their patents, understand how to manage the budget and their patents. So there, a lot of different, issues and things we have to challenge, we're challenged with in building and maintaining a team.
Anyone, Greg, I know you've got people that report to you. How much time do you spend, dealing with, I don't want to call them personnel issues because it's kind of a negative connotation, but really professional development and making sure that, people are doing what they want to do and are happy?
Yeah, I mean, it's a challenge. We've the mantra of more with less overall within companies, and so we've you have to balance the two, right? I mean, I think it said that at the end of the day we have things that need to get done, and then we have people that obviously want to learn more skills, develop more, and we try to balance the two. Within Eaton, we do a really good job of giving people additional roles if they're interested, and I'm sort of a testament to that regarding business counsel from before I was primarily just IP counsel. And
yeah, the problem with you is they did not give you more hours in the day.
Or more money, but anyway, just kidding. But it's great. I mean, they're supportive of that, and you get into these stretch roles, and it's in concept, it's a really good thing, the business counsel plus IP counsel, because you're really seeing it from a very holistic approach. But it's it's challenging from a time standpoint. But Eaton does a good job of that. It's really depending on the individual and what they want to get out of their career. Eaton will be supportive of that.
Yeah. So I didn't ask you guys this question on the pre-call because I wanted, it's a little bit of a setup. I want to see your facial expressions, because I'm a former in-house lawyer, as you know, and I'm now a service provider, and I do business development work. And so one of the things, this is the thing that drove me nuts most about being an in-house lawyer, and I sort of kind of stopped going to conferences just because this drove me bananas. And I wonder if you guys have the same experience. The question is, how many solicitation emails do you get a day? And how annoying is it? And do you have any recommendations for service providers that want to get in touch with you, whether it's outside counsel, Indian search firms, which if you guys think telemarketers are relentless, do not find your business card in the hands of an Indian search firm. And other service providers, because the one thing about intellectual property, which obviously has exploded in importance and in number of people paying attention to it, you have tons of service providers, and there are needs for a lot of them, but they always seem to be trying to square peg around hole sometimes. And how do you guys, do you see that, and how do you deal with it, and do you have recommendations on how people do or don't approach you?
Can I go?
You can.
I've got some.
We all have opinions.
I have some strong opinions, and these may just apply to me. So, things that you should not do. Don't email me with an invitation that you think that I'm going to accept. That will never work. In fact, that will get you in my junk bin, because I'll never get another message from you. Don't do that. Don't send me a tickler email that says, I see that you've gotten sued. Do you need counsel? Do you think that we don't know that someone has filed a complaint? All that does is tell me that, oh, by the way, this is the guy that I heard 6 years ago who I think might remember me. That won't work. So what should you do? We're here today, right? Come and say hi. Build relationships. So many of the people who I work with today in whatever services that they're providing are people that I've known for 5 or 10 years, who have spent time getting to know me, understanding how to work with me, understanding what's important, knowing when is the right time to ask, when is the right time to push, when is the right time to just leave me alone, right? And I think everyone just wants to be treated like a person. Nobody wants 17 spam calls, right? I got 7 yesterday. That will never work. Understand who I am. so that you can understand what it is that I need from you. Because that way, we're much more likely to call when we have a problem. All we need to know is someone who's responsive. So if I call, will you say, hey, we got this? It's the most important thing of all.
Chris?
Yeah, I mean, so for service providers, there's two categories, firms and other vendors. Firms, I like steak. I'm kidding. No, like it's kind of. No, it's actually like I think you realistically, like when you have an established practice, you're not looking for new counsel that often. Even if I'd never been sued before, I would be doing my company a disservice if I didn't have everything lined up, because those dockets move fast, right? I know who I'm going to, even if I don't if I go outside of a preferred counsel program, I know who I want to pitch the case with the litigation. If it's something else, I already have to have that Rolodex, right? So if you want to make connections and network and that kind of stuff, that's fine. But your timing of reaching out to me is never going to match when I actually need your help. So just don't try to get work. Just try to make friendships in the hope that, like, if you can make friendships, if we can have conversations and we talk about something other than law, then when the thing comes up that I don't have that contingency for, hopefully I'll remember you. Or like when it comes time that we're revisiting firms, updating for counsel program, hopefully I'll remember you, right? You'll never get the timing right on the outside. For vendors, this is going to sound terrible, but most of you just need to get better businesses. I actually look at all the vendor outreach, because there are certain problems that I cannot solve internally that I need an outside vendor's help for. I want to be able to see that what is the problem your business offers as quickly as possible. If I can't see that at the beginning, I'm just going to delete it and move on. If I see that it's a problem that doesn't interest me, then I'm going to delete it and move on. But sometimes those cold emails work because they're solving a problem that I actually have. And so, like, there's a vendor I hired this year that has financial data on company sales broken down by product category, jurisdiction, and matches that up with patent categorization. And so I can actually use that and say, like, hey, maybe I can make a more compelling case to finance and other business leaders about the defensive value of filing these patents, because now all of a sudden I'm creating a deterrent effect on another company's revenue. I can keep them from suing us. And so I was like, that's actually interesting to me. So I reach out to them, right? But most of the time it's like, I don't care about your translation service. So because I write on standard essential patents, it doesn't mean I want to hire you for standard essential patent valuations. I just find the subject interesting. I don't actually need it at Uber, but it doesn't stop them from sending all these things out that I just don't care.
Yeah, they clearly take a, sprinkle the infield and one thing will hit type of thing approach. Mahul, what do you think on this topic?
Yeah, so, first of all, I agree with what Jason and Chris said. I think, in terms of, reaching out, sort of same principles with networking, just building relationships. So, on the law firm side, building relationships, right? Getting to know you. I think the most meaningful relationships I found is where I'm getting something and they're not necessarily asking for something. So they share some insights from their experience or problems their clients are having. On the vendor side, we do use a lot of tools. And so in the off chance I see something that looks interesting, I may follow up. We want to keep up on trends and what people are doing and how people are using data, like what Chris mentioned, using revenue data. But the timing's never going to align. We're going to look when we're ready and when we need something. But I think as long as, someone can provide their business case or value or something interesting, even giving a sample saying, here's what our data looks like, or here's how we can help, that might get our attention. But yeah, we get several emails a day.
Okay, I'm going to skip you on this because I ran out of time. So we have a few minutes for questions. Ari Sherwin.
I mean, I don't think ever. I don't. It would be nice if they asked me who we acquire and who we don't, but it's not my decision. But it's never come up. Antitrust issues, and frankly, like that's a really expensive way to acquire category position that we're already acquiring today. Like we're growing our business relative to them. Why would we give them money when we can just continue building our business and take category position that way?
Atusa.
I wish there was a great answer. It's one of the things that we work really hard with our internal teams on, to say just because we have an NDA doesn't mean that you have an obligation to share information. It means that you can, hopefully you're protected, right? I mean, this is something that we all know. And I think that there's an inherent nature for the technical people that I work with who like to tell everyone how smart they are and who like to be as helpful to our potential customers as they can be. And part of what we've done, and it's taken a lot of effort, is to get people to understand, yes, we always want to be providing the best customer service that we can, but understand that if you give this away, even though you think that we're protected, it doesn't mean that we are, right? Because we're not always situated in the position that you're in, right? Where you're now dealing with someone who's much bigger than you, or we're dealing with people outside of the US where we might not have the same sort of understanding of the legal system and also the same sorts of ability to enforce things if we ever needed to. So it really is, how are we mindful of what information do we share? Are there things that we intentionally know that we will never share? Right? So even though we say, here are the 5 steps to the process, and we understand that you're going to manufacture, you'll told maybe 2 of them for us, but here's the material that's coming to you, here's what will happen after that. So we often try to do things like that where we're able to segment the information that we're sharing so that no one has all of it, so that it's more difficult to put things together.
I'll just add, like, so breaking your question down to 2 parts, protecting IP shared to Chinese companies under NDA, that's probably its own symposium. I would be interested in attending that, because I don't know the answer. But when it comes to like big, like let's say big US companies, the big behemoths, any company that has a lot of money has something to lose, right? And so there are ways that you can, as a small company, work with bigger companies and create the incentives to respect the confidential information that you share. Sometimes it's actually going beyond the NDA and actually, because like a lot of like template NDAs, has a very, you may have a fairly loose purpose clause because you're just starting that business relationship. But the sooner you can get to a more specific, like this is how you're allowed the information, this is how you're not allowed to use the information, and make them, if they want to engage further in business, you need to enter a real agreement that covers confidentiality as well as IP licenses and so that sort of thing. You can create the more with a big company with a big legal team that's scared of everything. The more like you can put on paper around that can pay off long term. And then the second part of that is we were talking before about like patent versus trade secrets, and actually when you have a case that's a patent case and a trade secret case, pairing those things together creates a lot of leverage. If you have when we were with the self-driving program, we would work with suppliers big and small, and they all wanted the same thing. Like we would give them some technology, we wanted them to build it for us, and they wanted to be able to sell it to other customers. We didn't want to be able to do that, right? And we always knew that was going to be the pressure, and we'd always try to get the contractual protection we needed, but then also that's where we would file patent applications so that we would have a patent sitting behind that. And you can craft like you can kind of divide up the world of information shared so that you can have patent protection and trade secret protection, especially when you get into specifications, technical drawings, that sort of thing. When something goes wrong, one, when you're dealing with business folks on the other side, they can't just negotiate their way out of a patent issue. Like all of a sudden, like business development folks are like, oh, geez, maybe we should take this more seriously. And we've gotten companies to back down on those requests because we could know that we have more IP rights behind there. But then let's say they still disagree, and you have to start enforcing. The combination of trade secrets and patents are very powerful in litigation, because if you ever like get jury feedback, or talk to a jury consultant, they don't understand patent infringement. Nobody understands patent infringement outside the people in this room, but they understand stealing, they understand copying, right? And so if you can tell a trade secret story in a patent case, it significantly increases your likelihood of winning the patent infringement claims too. But then you get into the reasonable royalties, which is just a free-for-all, and it doesn't even matter how valuable the invention is anymore, because that's not how reasonable royalties are calculated. And so you can end up creating much more financial leverage, and those big companies really don't want to lose a patent infringement case. So those are the kind of things I would look at if you're worried about a big behemoth misusing your confidential information.
So I'm going to close with two stories. One, on your point about how juries don't understand patents. I was on a jury trial one time with Patrick Norton when we were at Jones Day, and the other side introduced the fact that they had our patent in the room when they designed their product. And they did it because they wanted to show that they respect patent rights, and they designed around our patent. The jury was like, they copied your patent. And so when we heard the feedback from the jury, it's like, that was genius. The second thing is, we successfully got an injunction in a trade secret case in China. It was when I was at Dow, and the company that were under NDA with, just like Atusa described, took our drawings and built their own manufacturing facility. And on the side of the reactors, they literally had the same words that we had on our drawings. And otherwise, we never would have won that case. But it can be done. It takes a unique set of facts. Thanks, you guys, for coming today. We all were geared up because we told Krista that we would talk to law students about career advice for, taking an in-house role or what that's like. So we all have that answer in our head. If you're a law student, approach us at the break, and we're happy to tell you what we think. Thanks, you guys. Hope you enjoy the rest of the program.
All righty, we'll be on break for